Welcome back to Court TV Live. I'm Cody Thomas. Now our focus this hour is on Tennessee, where Zachary Adams is back in court this week in his bid for a new trial. Now Adams was convicted in 2017 of kidnapping, raping, and murdering 20-year-old nursing student Holly Bobo and is serving life without parole. Now Bobo disappeared from her family's rural home 6 years prior to that conviction. Now investigators found no DNA linking Adams to Bobo or the site where her remains were found. Prosecutors instead relied on testimony from Adams' co-defendant, Jason Autry, who said he witnessed Adams kill Bobo. Now, years later, Autry is saying he made it all up, recanting the testimony that ultimately got Adams convicted. Now, his defense team is now seeking to overturn that murder conviction based in part on that new information. Now, last month, Adams took the stand during this months-long post-conviction hearing, denying under oath he had anything to do with Holly Bobo's death. Now let's get you back in the court now, where the defense is wrapping up its closing arguments.
Could not say it better than Forrest Richardson. He analyzed quantity, not quality. Jennifer Thompson's problem is not that she didn't know the case. She couldn't tell the jury about it because by September 2017, she'd been ridiculed. Her own co-counsel filed a motion to withdraw, saying her problem was she believed him too much. I'm curious what the state's position is. Is it that she was competent, or in the words of Jennifer Nichols, dishonest and unethical for recording her work? Can you imagine if we didn't have the recording of Dinsmore and I was trying to tell you, Judge, I think there was perjury suborned during that day. I think Dinsmore said he didn't remember. If I didn't have a recording, they'd be like, whatever, trust us. Which brings me to the third large point. When you reflect on this case, whose presentation provided you the most credible proof? Whose statements to you were true? I told you from the beginning in May, Your Honor, Katie Spirko won't be a witness. You look in the record right now to see if there was ever a subpoena issued for her today, served on her today. I said it's for a nefarious purpose. Opening statement. The state said, if there's anything new that comes to this court, it's not going to be credible. I submit I have presented to the court objective scientific data that cannot be manipulated, like testimony of a fisherman 14 years earlier. The state has provided testimony from witnesses who lied about everything until their lies were nailed down to the lies of others. It was, at one point I asked a question and General Hagerman volunteered, this isn't gamesmanship. What else is it? If you don't think Jason Autry did it, then why continue to try to put him to death in pleadings? And his answer was, well, we didn't know who was going to be tried first. This is not a game. I've told you about the .32 revolver that we've never found from Dick, the second one apparently. It's been in a pond. Think about this. The state has asked you to consider the prior evidence, which is part of the record, that Zach made all these statements to drug addicts, to friends, to girlfriends he was fighting with, as somehow confessions. They have incarcerated him since March of 2014, had the ability to wiretap every single thing he's ever said, listen to every phone conversation he's ever made. They don't have the first sentence uttering a single statement that he had any knowledge of what happened to Holly Bobo or any involvement. They say that he threatened his brother. If that's the new element for first-degree murder, every parent who has children better watch out. And look at the people who supported the scientific evidence. Look what happened to them. Terry Dykes, taken off the job. John Walker, reported. Jennifer Thompson, antidepressant medicine. And Your Honor, I submit I have shown this to you, and in this case, I have taken their witnesses and their evidence, with the exception of Paul Dillon, Alberto Davis, and Bradley Strong. No, sorry, that's their witness. And the lawyers involved. I've taken their IRs, their agents, and shown you the truth. Your Honor, we're now time for me to tell you the fourth part of this argument and the last part of this case, which is your signature to the order. This procedure, this post-conviction procedure, Rule 28, and it's codified, reflects our country's dedication to the importance of our Constitution. Just as Marbury versus Madison said, some laws, however popularly passed, will not stand if they're unconstitutional. Neither will a jury verdict stand if it's the product of a constitutional violation. These provisions are not trivial. Due process, effective assistance of counsel. I will not lecture the court on the Constitution. I will just say this. It's what our men and women in uniform defend with their lives. Every judicial oath states you solemnly promise to support the United States and Tennessee Constitution. Each generation of Americans inherit the obligation to honor it, and if they don't, it will not stand. At times, it requires good and honorable men and women to speak up and stand up for it against powerful and popular forces. Is your signature going to be easy? Your Honor, it's not. The Constitution doesn't care if it's not easy. To put it in more practical sense, can TBI officers go around telling other witnesses to change their testimony to nail down with other testimony, and can prosecutors say, that's fine, let's use it? We'll find out with your signature. Can a prosecutor lie to the jury about a bullet size? We'll find out with your signature. Can a citizen honestly be said to have had effective assistance of counsel if the attorney was ridiculed, her first chair abandoned her, she had mental health problems, she never presented alibi evidence, she did not understand what evidence is important and how to get it admitted? We will find out with your ruling. Can the state mislabel, then lie about its existence? Evidence that either exonerates or tends to exonerate the witness, and then when they find a more clear version of this evidence exists, can they surreptitiously obtain it and tell the custodian, don't say a word about it? We'll find out with your ruling. Here's the irony, Your Honor. This ruling's not going to affect me. I'm going to go back to Hickman County and divorce people. I can tell you who is waiting on your ruling. Every dishonest member of law enforcement and prosecutor that is faced with a weak case. Your green light, if you condone this, will be the best they could have ever hoped for. And to be clear, I am not saying every law enforcement or prosecutor in this case or throughout the state is either dishonest or corrupt. We live in a state that prides itself in law enforcement, and we should. Those who do their job honorably have the utmost regard for everyone in this courtroom. It is to them this court owes the duty to not reward the bad conduct that besmirches their life's work. I would read to you from page 504, retired Agent Joe Walker, to be your guiding light. If there's evidence that cannot manipulate that Zach Adams was not part of this crime, you want him out of jail, don't you? If Zach Adams was in jail unnecessarily, sir, I couldn't sleep at night. I can promise you that. Is today the first time you learned that you did not look at the right video? Yes, sir. Do you feel terrible? Again, sir, I don't know. I don't feel terrible until I know for sure. You're worried, aren't you? I would hate to think that it would be, but I'm not certain at this point. No, sir. Chaucer wrote in Canterbury Tales, if the gold rust, what chance does the iron have? If Chaucer were here, he would say it this way. If this conduct in this case is not corrected in such a high visibility case, what's going to happen to the low visibility ones? Your Honor, subject to any post-trial filings as the court requires, this largely concludes my appointment to the court under Rule 28, Section 610C2, whereby I have reviewed the pro se petition, filed the amended petition asserting other claims which the petitioner was arguably entitled to, interviewed relevant witnesses, diligently investigated and presented all reasonable claims. To say that this has been disappointing and at times disgusting and even intimidated to present to the court would be an understatement. I read no such exceptions to Rule 28 that could have made this easier for me. I would be lying if I did not say I wish such exceptions existed at times. I found myself this summer working late at night often on this case and moving offices across the square in Centerville. One artifact I came across was an article in the Hickman County Times from 1981 where the then assistant prosecutor resigned because he was so upset at the corrupt, dishonest judge who presided over the court. The prosecutor not only wrote the resignation to the judge and the DA, he allowed it to be run in the Hickman County Times. The letter reviewed in detail the horrible acts from the bench this prosecutor had witnessed. And he ended it by acknowledging that this resignation made public will cause a financial cost to his future that he regrets. But he would rather his children grow up poor than to witness him stand silent in the face of such corruption and dishonor from the very institutions we cherish most in our country. The author had a daughter who has since taught history and government and a son who followed in his footsteps. For the reasons I have cited to you, Your Honor, I'm asking you to not stand silent either. Thank you.
All right, we do need to take a break now, but coming up, we'll get you back into that Tennessee courtroom for more of the post-conviction hearing and Zach Adams' bid for a new trial. And we want to let you know about a trial we will be bringing to you here live on Court TV in the new year, the Killing the Messenger murder trial. Now, 81-year-old William Brock faces murder charges for the fatal shooting of an Uber driver who investigators say was sent to his home by scammers demanding money from him. Now, the horrifying encounter was caught on the driver's dash cam, and that trial is scheduled to begin on January 12th, and you don't want to miss it. Keep it right here on Court TV.
I'm going to ask you a lot of intensely personal questions.
From the crime scene to the courtroom, this is victim to verdict.
Everyone has this heightened sense of anticipation.
What a day here at Court TV.
Fireworks both inside and outside the courthouse.
Let the cameras roll.
I don't care if death penalty is on the table or not. Absolutely, I'll to my dying breath, I'll be innocent, and that's the truth.
Back now to Tennessee, where we've been following today's post-trial hearing for Zachary Adams. Now, Adams has filed a request to overturn his conviction in the kidnapping and murder of Holly Bobo with the hopes of being granted a new trial. Now, this comes after his co-defendant, Jason Autry, recanted a testimony that solely got Adams convicted to life without parole. Let's head back into the courtroom now and listen to the state's closing arguments.
We do not care where Zach Adams was at 11:12 in the morning on April 13th, 2011. The state of Tennessee could not care less where he was at that time on that day. Out of their own witnesses' mouths, Agent Terry Dicus, the operative, the key, the essential time period in this case, in this investigation, 9:39 in the morning. He elaborated a little more and said from 8 to 10:30 in the morning. That was the key time. Their own witness. This court has heard proof since May. The jury heard proof for a week. Thousands of pieces of evidence have been admitted before Your Honor, before Judge McGinley. Often when we wrap up jury cases, we say to the jury as prosecutors, particularly cases like this, it's hard to give it to you. It's hard to turn this case over to you, ladies and gentlemen of the jury. We know you've been listening. We know you've been paying attention. We chose you. We know you're going to follow the law, but it's still hard to hand that case over. Your Honor is the jury here. And the state of Tennessee has the utmost confidence that Your Honor is going to do the right thing, that Your Honor is going to follow the law that says that they have to prove beyond clear and convincing evidence, or with clear and convincing evidence, that Jennifer Thompson and Jim Simmons and Jerry Gonzalez performed below reasonable standards, not magician standards, not wizard standards, not could you maybe bribe a juror and get them to hang this thing up, but did they perform at reasonable objective standards in the moment? Not looking back. All these years later, with hindsight, and I'd have done it differently. I'd have done this instead. Did they meet that standard? If they did, we're done. And Your Honor can proudly put your signature on that order. If they didn't, they still have to prove that it would have made a difference that when that jury came back into this courtroom, if they'd heard everything that Your Honor has heard today, plus everything that they heard during the course of the week of that trial, that they would have come in here and said, you know what? I don't know. Or just one of them. All it takes is one to say, state didn't meet their burden. I can't sign my name on that. Would any of this have made a difference? The state submits that the only difference what has transpired in this courtroom since May and outside of this courtroom in an attempt to manipulate these findings, in an attempt to manipulate and threaten witnesses, that the only thing that has changed standing here today, December 29th, 2025, is we know even more certainly how guilty he is. When we started these proceedings in May, the state pointed out that he, the defendant, sits before you, a convicted murderer in the state of Tennessee. And it's louder today than it was when we started in May. Because what the petitioner is asking the court to do is to look at the proof through a straw. Please don't read all of Mike Frizzell's report. Let me just scream and carry on about how the state hid evidence. If it wasn't so tragic to sit here with the Bobos in 2025 and watch them go through this, it's comical to carry to its ultimate conclusion what the petitioner is asking the court to believe. Please don't look at all of Mr. Frizzell's report. Just focus on the fact that he put that fourth ping on a later page. At no time did Mike Frizzell today or ever in front of that jury say, just look at this little piece of what I found. Look at all of it. Everyone who testified in this courtroom before Your Honor and who testified before that jury, with the exception of a few that I will talk about, everybody from law enforcement, look at all of it. Got it all. Here it is. I would hazard to guess that never in the state of Tennessee, perhaps in any state, I don't know, but in the state of Tennessee, never has a trial been conducted where the defense team had everything the state had. Everything. So this same petitioner who wants the court to believe that we're over here manipulating witnesses and telling people what to say and hiding stuff in our bags, I don't know, they had it all. They had it all. And we were at their mercy to receive the information. We were at their mercy to receive the information.
All right, let's bring in our guest this hour. Joining us to discuss is the Chief of Police of Talladega College and retired homicide detective Chris Anderson and Los Angeles-based criminal defense attorney Silva Megardician. Great to see you both. I hope both of you had wonderful holidays this past week. Now, Chris, I want to begin with you. We heard the state here just say, we know now even more, certainly, how guilty Zach Adams is. Now, you being the retired homicide detective, if you recall, there was no DNA or physical evidence definitively linking Adams to Holly Bobo or the crime scene, meaning the prosecution obviously relied heavily on witness testimony, witness narratives, and circumstantial evidence. You know, the defense even going as far to say the state was more in pursuit of closure than they were of the truth. Now, with this lack of physical evidence, my question is, how much weight should a jury give to testimony when there's no forensic proof to really back it up?
So thank you for asking the question, because I think that's a very important question. But before I get started, I got to say I offer my deepest condolences to the Bobo family. They are the ultimate losers in this whole case, because first off, you've asked this family to sit through not only going through the grief of losing a child, but they've also had to go through not one, but two trials, or multiple trials, as a matter of fact. So in this whole case, this whole trial that they're going through now is only bringing up the hard feelings of knowing that they've lost their child. So I offer my prayers to them. Now, to address your question about whether or not the jury should or they should, how much weight should be levied against the not having DNA cases. I've worked over 300 homicide cases in my career. I would have loved to have DNA evidence in every one of those cases that pointed directly to the defendant and to priest and a judge that were witnesses. But you just don't, it just doesn't happen like that at all in all cases. In most cases, you don't have DNA evidence that points directly to them. And then even in some that you do have DNA evidence, you have to really weigh that in how it was found, how it was collected. So, do I think that it should it be thought about? Absolutely. But should it completely throw the weight of the case against saying that this man is innocent? No, I don't think so.
Right, because people have to remember there was a time when we didn't have all this fancy technology and convictions were still brought upon defendants in cases nationwide. Silva, my question to you. Now, obviously, Jason Autry's recantation, this is probably the biggest grounds for the defense seeking this new trial here. Now, does this recantation alone create enough doubt to justify starting over, or is this more so just the kind of post-trial noise that we usually see out of these high-profile convictions?
Well, hi, Cody, and thank you so much for having me on. And, just also, Mr. Anderson is so right. Heart goes out to the Bobo family because, again, going through this emotionally for victims' families is so difficult. But I will tell you, Cody, to answer your question, the recanting witness is not enough by itself, right? Even though that was the main line of evidence is that he was convicted in the first place, but it's a cumulative standard and it's an extremely high standard. That alone is not going to lead to the judge to overturn this. But cumulatively, if the judge believes that a jury's verdict would have been different had they had this before, had the attorney been, let's say, more prepared, which I do think is the weakest argument that the defense has in this case. The fact of the matter is, defense counsel from that first trial looked, no matter what, even though she had gone through depression, mental illness, and the other attorney had left, it looked like he had proper representation. So the judge has to think of this cumulatively when making his decision.
Chris and Silva, we appreciate you both, your insight on such complex cases. We love having you on. You guys are sticking around for the rest of this hour, but we do need to step aside. On the other side of the break, we'll get you back to more closings in the post-conviction hearing for convicted killer Zach Adams. Welcome back to Court TV Live. I'm Cody Thomas. Now back to the post-trial hearing for convicted killer Zachary Adams. Adams and two other men were charged in Holly Bobo's death, with Adams being the only defendant choosing to go to trial. Now at that trial, key witness Jason Autry testified in graphic detail about how Bobo was kidnapped and raped before being wrapped in a blanket, thrown in the back of a pickup truck, and killed under a bridge near a local river. But now Autry is recanting that testimony as Adams claims that he made it all up in an effort to keep himself out of prison. Let's head back into that courtroom now and listen to more of the state's closing arguments.
But even for the sake of Your Honor's responsibility and the incredible job in front of this court, let's just say, for the sake of this argument, that it is clear as day that you can see the A-team in the front of that truck pulled in backward at the bank at 11:12 in the morning. Who cares? Holly's already dead. If that video had been taken between, let me make sure I get the times right from Agent Dykas, between 8 and 10:30, and you could see anything, yeah, that's a pretty good alibi. But the time is irrelevant. The state couldn't care less, nor does the law care, where this convicted murderer was after he'd already killed Holly Bobo. And all that the court heard in terms of alibi from Dylan Adams and this defendant was where they were after they killed her. Don't look too closely at what the proof shows as to where we were while she was being kidnapped, raped, and shot in the back of the head at the Tennessee River. Don't look too closely. Jennifer Thompson whether she looked at the video or not, she did spend time before going to law school as a computer programmer. And I think the court can see from the evidence that was admitted, the tech-savvy ability that she had. She knew what she was doing. She was an experienced attorney at the time the family hired her. She served then, she serves today on the CJA panel. Every accolade that you can have thrown at you as an attorney has been thrown at her. This one just didn't turn out the way she wanted. Whether she saw it or not, it doesn't matter. Because she had a strategy. And she had the best defense that has ever been handed to a defendant in the history of the state. And his name was Terry Britt. He looks and walks and talks like and is a registered sex offender. And it only takes one to not listen to all of the evidence and all of the facts and all of the law. That was her strategy. Imagine if this were all reversed and she had put the defendant on the stand and he had done a bang-up job at trial just like he did before the court with his selective amnesia. Oh, I don't remember where I was. Oh, I don't know where I was. No, I didn't say that. That was just a joke. Imagine if she put him on the stand and he had testified and that jury went back and convicted him. Then the accusations from this side would be, you should have blamed Terry Britt. You've got this walking poster child. Every defendant accused going forward is going to point at him. Why didn't you put on Terry Britt? Why would you ever put on proof putting these guys together? That's why the video is useless. Even if it showed anything, even if the time helped, why would she want to put them together? Her defense was to distance him from the others, the A-team, and to pin this on Terry Britt. But in addition, she didn't just sit back on her laurels with that as her sole objective. She cross-examined the fire out of just about everybody that took the stand. Can we sit here in 2025 with hindsight and say, oh, but you should have asked it this way? Sure, we can do that all day long. Thankfully, that's not what the law requires. The mandates of the law are for the court to look at the totality of the case at the time. And at the time and in the moment, and given what Jennifer Thompson and her team of 24 people that were working day in and day out around the clock while this case was in trial, their strategy was golden. Easy, succinct, easy to understand. Very rarely does a defense attorney have a name to put on the some other dude did it defense. This jury got to meet him and size him up and listen to her cross-examination and take it all into account and weigh it all.
Coming up, we will continue our coverage of the post-conviction hearing for Zachary Adams, and we want to look ahead to another big trial we will be covering in the new year, the au pair affair murder trial of Brendan Banfield. Banfield is charged with murdering his wife and a man who answered what prosecutors say was a fake post on a fetish website. Prosecutors say Banfield and the family's 23-year-old au pair plotted the murders as part of their romantic affair. That trial is scheduled to begin January 12th. Catch every moment right here on Court TV.
The world's attention is focused on what we are doing here.
He claimed dying was not a crime, but prosecutors thought it was.
This is a murder trial. Jack Kevorkian killed by injecting him with drugs.
Dr. Kevorkian has never in life intended anybody to commit suicide.
He was the only person that could help.
Michigan versus Dr. Jack Kevorkian. The trials of Dr. Death, weekdays at 2 Eastern on Court TV, Legendary Trials.
Back to Tennessee for the post-conviction hearing for Zachary Adams. Now, nearly a decade ago, Adams was found guilty for kidnapping, raping, and killing 20-year-old Holly Bobo, who had disappeared from her home 6 years earlier. Now, Adams' defense is now appealing his conviction based in part on the fact that his co-defendant, Jason Autry, says he made up his entire testimony where he claimed he witnessed Adams killing Bobo. Now, let's go back into the courtroom now and listen to the rest of the state's closing arguments.
Has great confidence and faith in this court. And just as much confidence and faith in our system. A system that provided this convicted murderer with every piece of evidence that the state gathered to prove his guilt. A system that allowed his team of lawyers and experts and jury consultants and forensic experts, and I mean the list is as long as this aisle. A system that never said no, that's too much money. We're not going to pay for it. Everything that Jennifer Thompson requested was granted. A system that selects from the community men and women, not lawyers, to second judge and second guess. Men and women of a community to listen to the law, to listen to the facts, and to never, ever, ever leave their common sense behind. A system that instructs that jury of their incredible responsibility that you must, every one of you, all 12 of you, find beyond a reasonable doubt that Zach Adams raped, kidnapped, and murdered Holly Bobo. A system that made everything available to him. Ms. Thompson was hired by his family and then convinced the court to appoint her. She kept him off death row. And a system that allows Your Honor to look at everything, what the jury heard, with the added benefit of what the court has heard now. And the absolute, unbelievable testimony that she just doesn't recall what he said, or that all of those communications with her client, every note she took, is missing. It's not plausible. The focus group that we asked her about. For a minute there, I thought, well, geez, did we read something wrong? And she had zero memory of that. And the court saw from the bar graph this morning from Forrest Richardson, 40 hours spent on a focus group. Dogged, relentless, obsessed. Zach Adams was afforded one of the greatest defenses and defense presentations and defense teamwork of any accused criminal in this state, to the tune of $275,000 for Ms. Thompson alone, just during the time that she was appointed. The standard that the law requires is light years beneath what she gave him. And even her dogged, relentless, obsessed attention to detail, quest to win, desire to beat Jennifer Nichols, none of it mattered. Because in the great state of Tennessee, in these courtrooms, the law is the boss. The law that jury followed and proudly walked back in here and returned their verdict to Judge McGinley, and the same law that Your Honor will follow. The same law regarding credibility of witnesses, reasonableness, prejudice. Would any of it have made a difference? The state submits the only difference is that verdict would have been a lot faster.
All right, that is wrapped up for the day. Both sides have settled. Now the judge will issue his ruling within 60 days. But let's bring back in our guests, Chris Anderson and Silva Megardician. Silva, I want to start with you, actually. How might prosecutors here, I want to go back to this recantation by Jason Autry, because that's just the whole thing here, right? How might prosecutors attempt to counter the impact of Autry's recantation, arguing against a new trial?
You know, Cody, it's because so much time has gone by. And what do you believe, the first or the second version? She really will attack just the credibility. And she did. And essentially the issue is, which part do you believe? And there's already credibility issues. You can't be sure that this version would have changed the jury's opinion. At the end of the day, Cody, that's all that matters. Anything that came out, would it have changed the jury's ultimate verdict? And that's what the judge is going to decide. And so that's the biggest issue.
And Chris, you know, ultimately here, we're doing all this years later. If a new trial does get granted, we have 60 days to hear if the judge will grant that new trial. Could either side, prosecution or defense, realistically, after all these years, recreate the same evidentiary impact as they did back in 2017? Or would this kind of be a whole new ball game here?
It's a whole new ball game, in my opinion. You know, I've never had a case that has been overturned. Fortunately, I've been very blessed in my career. But you know, I would think that it was a whole new ball game. Me as an investigator, I would want to go back to the beginning of when this case happened and redo everything, because sometimes, you know, even after convictions, things are missed, and a fresh set of eyes are usually able to catch those things that were missed. So for me, I think it's a whole new ball game. I think it's an opportunity, even if the case was overturned, it's an opportunity for those investigators to go back and try to recreate, and rebuild this case from the beginning in order to come back to the same decision that was brought before.
And Silva, kind of piggybacking off of that, going back to the beginning, recreating, that means you're going to have to recall, some witnesses that they called back then, I would assume. Now, the defense pushing for this new trial, but wouldn't there be a handful of challenges, in your opinion, Silva, met all these years later in reconstructing this story? I mean, you're going to deal with faded memories and faded recollections from people. This was, some of these people are growing older. We're not getting younger here. Don't you think there'll be a couple challenges there? What do you think?
Oh my gosh, Cody, understatement. Absolutely. Look, the statistics are really clear that a lot of times defense loses retrials because of the difficulty of recreating and reformulating after so much time has gone by. Memories do fade, and juries know that. So you really have to be incredibly diligent. As Chris said, it's a whole new ball game. You have to be not only better than the first time, but more resilient and make sure that the evidence that you put forward has no holes in it. And if you're going to have any kind of this person did it rather than my client, the evidence should be overwhelming, because the jury is going to try to not only beyond a reasonable doubt, but they want to make sure that there are reasons why their verdict is appropriate. So the defense has a huge burden to overcome, years and beyond a reasonable doubt for the prosecution. So the defense has a lot of work to do. But again, for justice to be served, sometime a retrial is the proper result.
Chris, Silva, again, we love having you two on the show. Appreciate your insight breaking down these complex cases, making our viewers understand it, sitting on the couch at home. We really do appreciate you guys. I hope you guys have a wonderful new year. Now, again, always a pleasure to have them both on the show. We'll see you guys next time. Now, I'm Cody Thomas. It's been a pleasure being with you. Now, coming up next on Trial and Error is the most infamous moment of the O.J. Simpson